delighted to be here, delighted with this invitation. I will start with what I think should be religious practice for people who are giving talks, which is disclosure. Not enough people do it. I see people showing up all sorts of places. They're working for clients, they're working for this and that, and they don't say. I think it's essential for the audience to know who people are and what they do so they can place you. Of course, if you know me, I say what I think, and it is independent of my clients, but you need to know who I work for. So my history is I've done a lot of work adverse to Google. I've done work adverse to Facebook. I've done some work for Amazon, some work for Apple, some work for Uber, some work for Microsoft, and for News Corp. I also work for governments. So it's a mixed bag, but it is, I think, extremely important practice to disclose fully what you do. So when we talked about what we could talk about, I said, well, why don't we just say the big regulation experiment? We can talk around that, right? There's so much happening around the world, around Europe, in the US, in Australia, that it is essential to just keep a bit of a landscape in mind as to what is happening, connect the dots. But I want to start a little bit to give my views as to why I think we are defaulting in this way to regulation from competition law. There is a common narrative out there, which is one that to some extent I subscribe to, that competition law as a tool has actually failed or certainly hasn't delivered in the space of digital in the way we would have liked it to. And that's the reason why we are moving on to ex-ante regulation, not as a substitute, but as a strong complement to it. And I think it's important to reflect in considering the design of the regulation that we're going to implement. It's important to reflect on what is it that hasn't quite worked in competition law, right? Because we're all in some way competition law practitioners, and I've been steeped in this world for 25 years. Why has it not worked? I would say probably three main things, many, but I would put the accent on three main things. One, there's been a long debate for some considerable times. Do we have the right tools in the toolbox? And everybody said, yes, nodding sagely, we do, but we don't use half of them, okay? So my contention remains that we are heavily biased in competition law in favor of the exclusionary, when it comes to conduct, the exclusionary tool. We know Article 102 has got two legs. One is exclusion, the other one is exploitation. But in effect, what we end up using in the digital field is mostly exclusion, which means tying, which means bundling, which means leveraging, which means enveloping. But there is also exploitation, and we don't use it. And it's one of the things that comes most naturally in this kind of space, because the kind of things we worry about are things that descend directly from the unevenness of the bargaining power between very powerful platforms and businesses or users that depend to a different extent on that platform. So it is this difference, asymmetry in bargaining power that lends itself to exploitation. We talk about data advantages, we talk about various other forms of unevenness of bargaining power, which lend themselves to be seen in the lens of exploitation. But we don't do it. Why? Because we don't have the precedent. The precedent that are there in competition law are to do with exploitation essentially used in what? Excess pricing cases in pharma. That's it. You got your Aspen, you got a bit of United Brand in the ancient history. You do not have enough of a precedent, and we are not willing yet to articulate properly what an exploitative abuse in this field really needs to be. We're beginning to see it. Germany is beginning to do it. France is beginning to do it, but not at the EC as yet. You still talk to the Commission. Everything is, ooh, that looks like an abuse. It looks like an exploitation. Whoops, exclusion, right? Because we don't want to go there. It is still quite a scary place. Number one, we don't use that tool. Number two, we are really failing in mergers. And I will go back to mergers later because I'll talk about that's still a gap in the design of the regulation. But certainly we know that what has created and entrenched the market power of the platforms has been a series of incremental mergers. And these have not been blocked, let alone examined closely. And so do I need to mention two words, Google Fitbit? Anyone who knows me knows I've been quite animated by this particular merger of kind of being at the forefront of a group of economists and privacy people and civil liberties people and various other people and consumer people worrying about that deal. But fundamentally, the reality is that at this point, we've been and we continue to be far too timid when it comes to blocking these deals and to investigating these deals. There's a number of reasons, which I understand. In the case of Google Fitbit, the commission was still reeling from the defeat in court on the UK 023 case on the Apple tax, and the internal mood was very much, we will lose it in court and we cannot block this. But it isn't until we really just pick up the courage to do these things and accept that there will be more defeats in court, and therefore the standard needs to be changed, and therefore merger control needs to be absolutely updated, that we are going to continue to see other deals like this one getting through with absolutely unworkable behavioral remedies instead of being blocked as they should. But I'll return to that. So, to merger control. Third, this was an interesting discussion that was kind of started, but never enough time, at the Bundeskartellamt office yesterday. This idea that we in Europe are far too polite and careful to contemplate breakups or vertical separation. This is something that, as Europeans, you always talk to regulators and they say, no, that's the last resort. We don't do that. And it's very interesting because it is a very different posture from the one that is coming across very strongly in the US at the moment. So someone I quite like, she's quite radical, but I quite like, Zephyr Teachout, spoke very well about this earlier this week, and she illustrated how really in the US, this goes back naturally to a different tradition, which is one in which before you had consumer welfare as the animating spirit, the animating principle for antitrust, you had different principle. You had the dispersion of economic private power as the animating principle. This is an important tradition in the US. The notion that you are dispersing private power because that is necessary not to create political power, not to create the kind of things that we're worried about. That is something which is well established in the US and currently animates much of the debate about, and is behind the debate about, should we break things up as a result of the various complaints and actions that have started to emerge. In Europe, of course, we don't have this notion of dispersing power. We come from a different tradition. We come from an ordoliberal tradition in which what we care about, and I'm not a lawyer, but what we care about is really sort of much more the notion of fairness and the notion of, competitors effectively being given a chance to compete on the merit, rather than dispersion of power. But I find this notion fascinating because it is something that in the US kind of inspires the view that separation, even vertical separation along the lines of line of business restriction or the like, is not beyond the pale. Whereas here in Europe, we are so incredibly unwilling to even begin to contemplate that. Now, I understand the geopolitical dimension. You cannot go and break up an American platform just in Europe, but you could do things that are more targeted. And I'm not in favor of indiscriminate breakups, but you can certainly do things that are more specific and targeted, or create line of business restriction. Even purpose limitation for data is a form of separation of some sort. So there are solutions that we are not very willing yet to accept. And yet we are witnessing, beginning to witness, certainly at our end too, the sort of the toxicity of certain business models that are built on maximizing surveillance, addiction, dark patterns, prioritizing conflict, and so on. And this is something which should be at the front of our mind. So instead, when it comes to solutions in the antitrust world, in the competition world, we have been contented with these behavioral remedies that do not do anything. We've been at it for 10 years. We had The shopping case started in November 2010. And yet, 10 years later, we haven't moved the dial. We are still here discussing the remedies in shopping, the remedies in Android, none of which has had any effect. There was a very good academic paper published recently about the Android remedies. I've been saying that forever because I was in the Android case. I was saying to the commission, but what is this going to do? What is this auction going to do? You have an auction to appear on the phone, which is going to have the little mice paying Google to appear here. Who is going to choose them? How is this going to change? How is it going to move the dial? None of this was obviously going to do anything. And yet we go forward. We're in a world in which we say, cease and desist, don't do it again, okay? And then the company comes back and says, okay, here's a solution. Is this okay? Oh, okay, let us market test it a little bit. The market screams, but nonetheless, you go ahead with that solution. So the remedy design in Europe has been a total utter disaster failure. We have done nothing, which is why, you know, when you talk to US counterparties, you say, well, we in Europe, we've done something, right? You've been sitting on your backside for 20 years. You've done no enforcement. What do you want? And they say, yeah, well, where did you get to, right? That's the question. So these are the reasons why ultimately competition law as a tool hasn't worked. We are finding ourselves still contemplating the entrenched market power of these players and wondering how to go about it. And of course, if one takes another step back, what's behind this? And I would like to mention a couple of things. What's behind it? And I've been in this for 25 years. I have seen the arc of this, okay? Because when I came into this business 25 years ago, I felt that we, the economists, were coming in and somehow were introducing rigor and principles in what was a really hand-wavy way of doing enforcement. I think after this 25 years, I'm no longer sure that we've been a force for good. When I really leave, I will write something which will make people's hair stand on end because I know where all the bodies are buried. But seriously, there is this tyranny of the type 1 error, which has been the dominating, animating principle for enforcement, and the scream that has come consistently from the lawyers, from the economic advocates through time. Don't over-enforce, because if you touch this amazing machine, this amazing miracle, there will be a loss of innovation. Innovation will die. Now, I'm old enough to have been around in 2001 during the Microsoft case, the very early one. I was adverse to Microsoft in those days. And I remember these very arguments. Microsoft was saying, if you touch us, the world will come to an end. There won't be any innovation anymore, and the rest is history. So this old chestnut, that if you over-enforce, there will be death of innovation, is ultimately a religious belief, which is being pursued by the dominant companies and their advocates, for which there is no evidence. There is no theory that supports that. There is no empirical evidence that supports that. Take it from me. I've looked, and this is all a myth, okay? There is no agreement in theory, even whether, for example, mergers increase or reduce innovation. You still have a gazillion models that, depending on the assumptions, can tell you yes or no. So there is no consensus. And when it comes to empirics, there is no consensus. There is no evidence that innovation is being undermined. Do we really think that people in Silicon Valley will stop innovating because one stops 2 more mergers? I don't think so. So this has been a myth. The other thing that I think is important and we have failed to do is really the fact that we, as competition bubble people, have failed to recognize the importance and the role of data protection and privacy in the market power. We've proceeded for years with this other myth that says, oh, data protection is for the consumer people. This is consumer protection. We don't do that. We're the competition people, right? Oh, and there's other myth. There is conflict between data protection objectives and competition objectives, right? So, you know, don't look over there. This is the privacy people. We are the competition people. And the thing that is missing here is really that the source of the market power is precisely this accumulation of data and information on us, which is by now so entrenched. And if we don't understand this aspect, we are failing to also tackle the competition aspect. So one of the things I set myself to do is really try and understand a little bit more and create more of a dialogue between, there are people out there who are real amazing data protection, data privacy people like Johnny Ryan, Michael Veal, you know, others, Wolfie Crystal, people, Francesca Bria. These people are completely separate from the competition world, and they look at us and say, what are you thinking? What are you thinking over there? Why don't you see what we see? Why don't you see the violations that we see? Why aren't you taking them into account? We, the competition people, are ignorant as raccoons when it comes to privacy. And we don't really talk to the people who matter. So this is, and this was also Google Fitbit. You know, when you were talking to people in the privacy field, they were like, what are the competition regulators doing? This is obvious. Why are they not blocking it? And I was like, well, you know, we do some stuff. We do a little bit of foreclosure over there. And I'm like, you guys are nuts. You know, you guys are sort of doing irrelevant things. And so I think that that's another reason. And generally, and the last reason why I think, you know, the problem with competition law persists is that inevitably, because of all of these constraints, regulators have been far, 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 far too timid. I think, I mean, if you talk to the companies and their advocates, they're all saying the regulators are mad. I think the opposite. I think there is a restraint, which is remarkable still, which is ultimately colored by the fact that you have the courts who are such a problem in all of this. Because of course, rule of law, the courts, the US true too, not just in Europe. And I think the courts have been a real source. I mean, obviously, some of the lawyers on the other side will hate me for saying it, but the courts have been a real source of breaking progress in all of this. So that's where we are in competition law and why somehow there are these kind of great big gaps. So then what's next? So then everybody says, well, okay, let's do regulation. We do regulation because competition law is what it is. We haven't really succeeded. And now let's do regulation instead. So we got these proposals on the table. I'll be sort of giving you my tour d'horizon as to what I think. My views are known. So great. We have the DMA. Great effort. And I absolutely agree that we totally need to complement this incomplete tool of competition law with something which is a bit ex ante. I've said it before and repeatedly that I think what I don't like about the DMA is that it pretends, it aspires to being something fairly general, coming out with rules that in principle should apply across the piece, but I think are actually not specific enough or clear enough for people to understand what applies to them. So it's clear what happened there is that the Commission took a pile of pipeline cases, current cases, past cases, all put together, and then each of them, you know, on Apple, on Google, on Facebook, etc., it kind of took out of each of them something which looks like a paraphrase or an abstract and put it into Article 5A, 5B, 5C, etc. And so if you squint and look at it and say, oh, that's Google, that's Apple, that's Amazon, but how general is it? So if you think about, let me give you some example. So 5A, something which is a general prohibition. The platform should not use data that are created by sellers on the platform to compete against the sellers. Okay, that's Amazon Marketplace. How does it apply to Apple? How does it apply to Google? How does it apply to Facebook? How does it apply to Uber? Uber says, I've got no sellers. What are the sellers? I'm going to drive a data, go ride a data. What do you want from me? I'm going to look away. So another one, do not self-preference. Self-preference means different things under different business models. Is it the case that every time Amazon recommends a product that is Amazon Basic itself preferencing? Are we thinking about something different, something more sophisticated? So you see the point. I think the reality is that we need to be actually more specific when it comes to the rules that we want to put out there, because we don't want people to circumvent them and say, well, that's not me. Was that me? No, not me. I don't know. What do you mean? So I like the UK approach very much in all of this, because the UK approach is one in which it is recognized that companies have got different business models, and therefore rules of conduct need to be defined for a particular platform without ambiguities. So you Google, this is your rule. This is what you do that we don't like. This is what you, Facebook, do that we don't like. This is what Amazon does that we don't like. This is what Apple does that we don't like. But they're not the same. There are some common principles. And it does worry me that people talk about all of this as we need to implement absolutely general principles of, telco style open platform, open access, everything the same. Well, not everything is quite the same. Not all the business models are quite the same. Access is not the same. Separation is not the same. So I do think that in order to make sure that ex-ante regulation actually applies and bites, and people actually do what they're supposed to do, you are very clear with them about what they're supposed to do. And again, I like the UK approach, which is one that has in mind specific codes of conduct. This is the UK proposal for specific platforms. This makes a lot of sense to me. The alternative to this, or the alternative, another way to go, I mean, this regulation isn't going to sail through completely unopposed, right? Because you can see that, of course, there is great appetite in the parliament to just rocket this through. There was talk yesterday that the DMA would be approved under the French presidency early next year. But simultaneously, you also have member states saying, oh, wait a minute. I mean, we are doing our own thing over here. So Germany is quite ambivalent about this. And of course, Germany has approved the amendment to the competition law, which has created this sort of almost hybrid structure in which you have still, Article 19, but you have an Article 19A, which has been newly introduced, that basically specifies that for certain categories of agents, these ones with paramount role, you basically have these rules that you have to abide to. And what I like about that is that you don't lose the specificity of competition law. This is the sort of the dilemma here. Competition law is case by case, okay? And that allows you to actually study the business model, understand the problems, and specify the rules for that company. Takes too long. Want to do something else, which is ex-ante, okay. But then you need to be specific to the platform too, because if you make it too general, then it doesn't really self-police, because it's going to be absolutely easy for people to say, this rule doesn't apply to me, doesn't mention me, so what do you want? So I think that I would like to see the next evolution of the DMA as being one in which the rules are more specified. My criterion is business models. You need to say, well, if you're upfunded, if you're a transaction type of model, if you're a platform app store type, these are the rules. If you don't want to do company specific rules, okay, we are in Europe, we don't want to do a law for Amazon, but then let's do something which is business model oriented. Okay, you're a matchmaking, you're a transaction, you're a commission-based platform. This is kind of what applies to you. You're an ad funded, this is kind of what applies to you. And if you're an app store type or an operating system, this is kind of what applies to you. And they're not the same. So that would be my suggestion. Very briefly, because we are at the half hour, very briefly, another 5 minutes. I want to say something again about mergers, because I think that in digital, this is the nub of the problem. We have allowed power to be created through incremental mergers as well as, of course, the notorious aspects of the markets, network effects, economies of scale and scope, and all that. And we haven't done anything. And really, what has failed in Google Fitbit, for example, which remains very clear, very close to my heart, has been really the difficulty in putting across to the Commission the notion that what was at stake was not just the use of data in personalized advertising, which is something they understood and recognized, was not just the complaints of the commercial complainants. There were commercial complainants. I had nothing to do with that, but there were commercial complainants in the game. There were the Garmins, the various other characters who were complaining. They were worried about losing the interoperability with Bluetooth, with Android, and wanted to maintain that. So fine, the Commission is used to these kind of commercial complainants and to have the remedy game effectively as a way of trading, remedies that satisfy the complainant. So that was kind of taken care of with a standard interoperability remedy that's been done before. But the thing that animated all of us was like, what? So you have the most gigantic data asset in the world with data about us in every conceivable dimension. We're now letting them get on top of that health data, okay, and put it together and identify signals from us. We know how artificial intelligence, machine learning works. This could have enormous implications for future user cases, from insurance to health. I'm there at night and I'm searching something about a health condition. I'm doing something on the internet, and simultaneously my pulse starts racing. And these kind of signals can be put together. Or there is something about me that suggests that I'm looking at something and I'm anxious about it. All of this can feed, and health tech is going to be the next. It's the current billion dollar industry, in which all of us may be discriminated in ways that we don't begin to understand on the basis of health characteristics, features that we don't even know about, employment, insurance, similar things. And it was incredibly disheartening that the Commission didn't take that on board. And they didn't take that on board because, of course, they say, well, there wasn't clear evidence that that's what they were going to do in the internal document. And this is where, one needs to think about what are the standards of evidence that we use in these mergers. There is a range of proposals. Some people, and I'm not talking about the extremists, people like Nancy Rose. Nancy is a professor at MIT, and she used to be the DOJ chief economist. Nancy said last week, OECD, she said, I think that major dominant digital companies should simply not be allowed to do a deal, to buy anything. Forget it. That's the kind of. Others are saying, well, reverse the burden of proof. Show me that there are efficiencies and reasons why you should do it. So the point is, I do understand that a regulator like the Commission says, Google is threatening us. Google is saying, if you just block this deal, we are going to sue your ass and we're going to lose in Luxembourg, because that's how the judges kind of are going to see it. What do you want us to do? Now, I always thought it was a wonderful thing that Shoshana Zuboff, the surveillance economy prophet, she gave a talk to the European Parliament not long ago, about a month or two ago, while the Google Fitbit matter was still alive. And she was incredibly eloquent. And she was talking to the MEPs, and she said, which I thought was wonderful, if what is preventing your Commission from blocking this deal is that it doesn't have the right laws, you should stop listening to me right now and file back into the chamber and vote the law that will allow the Commission to knock down this deal, because this is what you should be doing right now. Now, thank God for Australia. We'll see what happens there. But unfortunately, it was what it was, and we're going to see more. This Facebook customer on the cards, is the Giphy one, we'll see. But I think that is an area of major change, which is not dealt with by the DMA. Why? Okay, there's a reason. The DMA is under 114, I'm sure you'll all know, and it isn't about merger control, but somehow someone needs to do something about merger control. And the UK, again, are doing it because they have in their own DMU proposal indicated that they intend to adopt a regime which also looks at digital mergers as a special case in which the burden of proof is lowered by. So essentially you are there and you're saying, I'm a digital platform, I'm doing a deal. Okay, that's your door. Come in this way. We're going to talk about that. Final thing, which I want to tee up because it is, of course it was difficult to miss in the last couple of weeks, was the Australian matter around the Google Facebook payment for content, as you know. Now, this is something I want to mention because in the big spirit and scheme of things, I do think we need regulation experimentation, right? Nothing should be off the books. We need to think about ways to do things that are creative and novel in designing the regulation. This is not telco. You're not going to do access pricing in the same ways you did with the telcos of old, which all look the same. This isn't it. You need to be really quite smart and creative. Now, Australia gets my vote. I'm incredibly partial to Australia and to Rod Sims, who is total hero in my mind, because they have done serious work. They haven't woken up one morning and decided to do this. They have done incredibly serious work, pioneering work on digital markets. They have two incredibly thick and very, very valuable reports that identify market power as being a problem. And then they did decide to tackle one particular aspect of it. This isn't a global solution, but it is one aspect. It is the notion that that platforms are using content and not paying for it. And now, this, of course, in the last 2 weeks has blown up because of all of the things you followed. I should say that I've written on this and I'm very favorable to what Australia did, not because as many sort of think, oh, this is kind of giving in, Australia giving in to Rupert Murdoch. I don't care about Rupert Murdoch. You should shoot, News Corp, you can shoot them to the moon as far as I'm concerned. The issue is not that. The issue is that once you make a decision, a political decision ultimately, founded on, of course, a lot of work, that there needs to be some sort of contribution being made by platforms to journalism. That is the policy decision. It is a policy decision that is made by governments, by regulators. Then what I quite liked was the idea of the final offer arbitration that they put in place, because it is quite creative. It does concentrate minds. It's different from, okay, now platforms write a check to the press, or government write a check to the press. It is something that in some way embodies a little bit of private information, which I prefer to the idea of 50 submission to a regulator and the regulator having to say the number is X. Of course, this was, and I'll conclude here, was of course, they gave a lot to think about to the platforms, and people say, well, in the end, did Australia really win? Because in the end, Google and Facebook ended up doing private deals with a handful of newspapers, and no, Australia did win. Australia did win because if it hadn't been for the threat, for the shadow of final offer arbitration, there is no chance those deals would have been signed. The law is now in force. And so, there are, of course, a lot of things to be thinking about. How do the smaller kind of publishers fare in all of this? Do I think, there's a lot to think about, but it did have an effect. And I think it was incredibly interesting to watch how this whole thing, you had all the wind-up toys of Google and Facebook sort of writing madly on Twitter, writing madly everywhere, saying, this is a piece of genius. The tech writers saying, this is about money. Well, no shit. Of course it's about money. It's money from here to there. There's a policy decision which is being taken that money should be flowing from one side to the other. So it isn't a genius insight that this is about money. But the point was, how do we actually fashion that payment? And the way in which it would have worked with final offer arbitration is to say, okay, you cannot say, I owe you 0 and you owe me 3 gazillion millions, right? Because the arbitrator can choose one or the other. So, you know, you just kind of come a bit closer because you know that he's going to choose you or you. So there's no point being so dispersed. And show your workings out. If you say it's 0, then show me your maths. Show me that you have no value that you attribute to these things. And then the arbitrator can take that into account. So to final thing, I think that Australia ought to be applauded, and I'm very much a fan of what they did, and I hope it catches. I'll stop here.
Thank you very much, Cristina. It was really, really appealing and stimulating. I'm mindful